Hello everyone, welcome to ixambee's law channel Legal B. Yesterday we started with a series on legal maxims and we discussed the first legal maxim ab initio. In the end I gave you a situation and I asked you to which legal maxim this situation relates to. Briefly, the situation was that A had beaten B on the road and a lot of people have gathered around. My question was whether the statements of the bystanders C, D, E are relevant or not, and under which act, under which section, and to which maxim does they relate to. Continuing with our second legal maxim, this situation relates to the legal maxim res gestae, that means forming part of the same transaction. This legal maxim is related to the law of evidence and it falls under the Indian Evidence Act under section 6. Under Indian Evidence Act, the first topic, that is relevancy of facts, talks about all the facts which may be fact in issue or which may be relevant fact. Only these are the two types of facts which are admissible in evidence: relevant facts or fact in issue. Now, whether any particular fact is a relevant fact or not, that is defined under various sections under Indian Evidence Act, and section 6 deals with those acts which form part of the same transaction. In section 6 it is clearly mentioned that the facts, they may not be in issue, but they are so connected with the fact in issue that they form part of the same transaction. They become relevant whether they have occurred at the same time or place or at different time or places. So in this example, whatever A has said or done, whatever B has said or done, and whatever the bystanders C, D, E had said or done related to the fact in issue, related to the fact that A had beaten B on the road, is irrelevant under section 6 of the Indian Evidence Act. What are the key points under the doctrine of res gestae? The first thing is that it is a rule of evidence and it is an exception to hearsay evidence. What is hearsay evidence? Simple words में hearsay का मतलब होता है सुनी सुनाई बातें. In Indian Evidence Act, it is clearly mentioned that oral evidence must be direct. मतलब जिसने क्राइम को विटनेस किया है, जिसने कोई इंसिडेंट देखा है, वो आकर टेस्टिमनी दे. जिसने कुछ सुना है वो आकर टेस्टिमनी दे. जिसने कुछ सेंसेस से फील किया है वो आकर एविडेंस दे. दैट मीन्स अगर ए और बी के बीच में केस चल रहा है वेयर ए इज एक्यूज्ड, C is a person who is being called to give evidence, then C should be a person who himself had witnessed the crime or heard something. ऐसा नहीं होना चाहिए कि D was the person जिसने विटनेस किया था, जिसने मर्डर होते हुए देखा था, और D ने C को बता दिया और फिर C आकर टेस्टिमनी दे रहा है. No, this is hearsay evidence and hearsay evidence is not allowed in Indian Evidence Act. But under the doctrine of res gestae, under section 6 of Indian Evidence Act, all the facts which form part of the same transaction are relevant. Another key point that we have discussed earlier is that the rule of res gestae is embodied in section 6 of the Indian Evidence Act, and this was said by Supreme Court in Bhairav Singh versus State of Madhya Pradesh. In this case, the Supreme Court clearly pointed out that the rule embodied in section 6 is usually known as the rule of res gestae. Let's take some examples and understand क्या क्या res gestae में आ सकता है, क्या क्या same transaction का part बन सकता है. The first one is the cry of an injured person or wounded person. अब मान लो A ने B को stab किया है and B screamed out of that. या फिर ए ने बी को स्टैप किया और बी के बच्चे उस वक्त जो घर में थे, दे स्टार्टेड स्क्रीमिंग, दे स्टार्टेड शाउटिंग. उनकी स्क्रीम्स को जिसने सुना, he was not the person who was witnessing, but the screams formed the part of the same transaction. The cry of an injured or wounded person, the cry of witness on seeing a murder happening, the sound of a bullet being shot, all these come under the doctrine of res gestae by the fact that they form part of the same transaction. Let's further try to understand this with some important case laws. The first one was Thompson versus Trevanian in 1693. This was the first case where the rule of res gestae first appeared, And it was held in that case that the declarations which are accompanying any act, whatever is being declared, whatever is being said, they are receivable in the explanation of that particular act. Then there is another famous case law, that is Ratten versus Queen. In this act, the husband was accused of killing the wife. The husband has shot the wife and he was being tried for that particular offense of murder. The husband took the defense that he accidentally fired the gun, it was not intentional. Prior to that act, the wife had called the emergency helpline number to report that her life is in danger. Her call, due to certain circumstances, was not able to connect to the police department, but it reached to the emergency helpline number. Later, the wife's dead body was found in her house. In that case, the court held that the call forms a part of the same transaction, a part of the same murder, and it implies that the murder was not accidental, it was intentional, and hence the husband was convicted. So in this way, there could be various acts which may not be relevant otherwise, but become relevant because they form part of the same transaction. However, there are certain rules that must be kept in mind in order to admit evidence under res gestae. The first thing is there should be close association of the statement with the event. तो जिस इवेंट की बात हो रही है उससे स्टेटमेंट बहुत क्लोजली एसोसिएटेड होना चाहिए, either by proximity of place or by proximity of time, या फिर किसी एक्शन की continuity हो रही है. For example, there was a case in which there were two persons who were walking on the road. उन्होंने एक बहुत ही स्पीड में एक कार को जाते हुए देखा and कुछ देर बाद they heard a scream. That car had hit a person. Then these two persons who were walking on the road, their statements were admitted in evidence under the rule of res gestae. Then another close association could be by the community of purpose. Then there is one more famous case law, Gentela Vijayvardhan Rao versus State of AP. इसमें क्या हुआ था? There were two persons who had boarded a bus with the sole aim of robbing the passengers in the bus. बस में चढ़ने के बाद उन्होंने पेट्रोल छिड़का और बस को आग लगा दी और and they jumped out of the bus. Whatever passengers were able to jump out of the bus, they ran after them and robbed them. In this case, there were certain statements of the witness which were recorded by the magistrate after a long interval of time, and those statements were found to be inadmissible because of the lack of proximity of time in recording the statement with the event. Thus, res gestae is based on the belief that because certain statements are made either naturally or spontaneously or without any change, without deliberation during the course of the event, then there could be very less chances to misinterpret them, to misunderstand them. For example, the cry of injured person or the cry of witnesses, and thus the courts believe that such statements carry a high degree of credibility. However, the meaning of this doctrine of res gestae is unclear and it is not definitive. It is not defined what falls under res gestae and what does not fall. And the discretion is left to the courts to consider whether any relevant evidence comes under the principle of res gestae or not. So this was all from the res gestae. Now I'll give you another situation. Try to guess to which maxim it relates to and write down in the comment section below. So there is a person A. This person has been called as a witness in a case. Here in this case, A lies. A gives a false testimony which was discovered subsequently during the proceedings. Then there is another case where the same person A is again called for witness. Can this person A be called for witness, or just because once he has lied in a testimony, he is not credible to give another testimony? If you want to get in touch with us, you can call us on the number mentioned on the screen. You can also visit our demo courses to check out for which law exams we offer online courses. Subscribe to our channel to get regular notification with respect to this legal maxim series and also for any upcoming law notification. Thank you.